security in the healthcare environment. Just as a point of reference, between 2010 and 2014, 37 million healthcare records were compromised in data breaches in this country. And in the first 4 months of this year alone, in 2015, more than 99 million healthcare records were compromised through data breaches, through 99 separate attacks. That's the official impact of privacy and data breaches on our healthcare system. Unofficially, and with the proliferation of apps and devices throughout our healthcare system, the unannounced and unaware data breaches that we're dealing with are more significant. We're very pleased to have with us two outstanding presenters from the Pepper Healthcare team. One, Barry Boyes, a partner and vice chair of the Health Effects Litigation section in our firm. Barry is an outstanding litigator. He's handled major pharma cases throughout the United States. He is a person who's done a lot of work with attorney general's investigations, handled multi-state consortium and private plaintiff-led litigation, and defended numerous companies and entities throughout the country. We're very pleased to have Barry present, along with one of our outstanding young lawyers, Stephen Jenkins. Stephen is an associate in our commercial litigation practice, and he has been involved in a number of issues in litigation involving compliance and privacy, unfair competition. He is a key member of our privacy, security, and data protection practice. He's authored multiple client alerts on privacy issues and data breaches, and he has become an expert as a young lawyer in this area. So I'm going to turn it over now to Barry as we move forward and talk about some of the multiple ways in which these medical applications and mobile devices have impacted in healthcare. Barry, take it away.
Thank you so much, Mark, and I'm delighted to be here and present on this topic. It really is hard to get through any day without seeing some headline that is addressing the issue of mobile application, whether it's researchers who are investigating a new device to help epilepsy patients, where sensors from an Apple research kit or Apple Watch is able to detect acceleration of heart rate and also detect whether someone has collapsed and send an automated message to a healthcare provider or family member that's under investigation, or whether it's more simple logging or journal activity where patients can help with medication adherence and also to detect and record when they have side effects and present that information to their healthcare providers. iPhones, cameras are used, at least in research right now, to examine and perhaps market detection of melanoma, being able to trace moles in size and shape and color and evaluate someday with potential algorithms whether those changes are meaningful. And with all of this innovation, there is a convergence of really two important issues, and Mark really set it up well. One is privacy. All of this biometric data being collected raises significant privacy concerns. But in addition to that, and really biometric and health information itself is subject to attack. And it's subject to attack because it is so valuable. As one recent study noted, health records have a 20-fold times worth in the black market than even financial records do. So privacy cannot be underscored enough when it comes to protecting this data. However, with medical applications, there's really a second thread that's being pulled on here, and a very significant one, and that is one of patient safety. So when you're dealing with privacy and health information alone, there is a crowded regulatory field that is interested. But when you add patient safety to the equation, the field gets even more crowded. For those watching and who are covered entities in the healthcare space or business associates of covered entities, certainly HIPAA and high tech is quite familiar, and the regulations and enforcement by the Office of Civil Rights is something you're well familiar, as well as state attorney generals that enforce those important privacy laws. With mobile applications, the FCC has expressed an interest as they regulate our airwaves. In addition to that, now we have the Commerce Department that formed the National Institute for Standards and Technologies, which formed a national center for cybersecurity of excellence, which sets standards for medical devices and the storing of electronic health records. And that guidance is still in draft form. Comments period just closed this past October, and hopefully that will provide some more guidance for industry in how to maintain the privacy of electronic health records. But today, and really, so privacy alone can create a number of risks and regulatory exposures. But today I want to also, and Stefan and I will focus on additional regulatory agencies and enforcement and non-government enforcers, so to speak, and that is the FDA, the FTC, state attorney generals, and then we'll touch a little bit on consumer class actions, as collectively these field of regulators can create enterprise risk for companies, whether it's damage to reputation, direct financial impact, diversion of resources, and of course litigation involving any type of data breach and certainly any type of risk to patients and safety concerns. And dealing with these issues collectively is what is now so important. Any one of those issues can create a concern, but collectively it can certainly generate potential enterprise risk. But as I mentioned, today we really want to focus on the FDA, FTC, state attorney generals, and then touch upon consumer class actions. And along the way, we really want to provide some distilled takeaways, some things that you can take with you, hopefully, that will help you protect privacy, understand where standards are evolving, and understand the regulators' view on these topics. So first, with respect to the FDA. The FDA has spoken on the topic of medical devices and cybersecurity in a few guidances, and as an aside, when I talk about guidances, we will list those in resource material at the end of the slide deck, so you have both the reference material that we cite to today, as well as any publications, recent publications that Pepper has presented on these topics. So we're covering a lot. We want to give you some key takeaways, but rest assured that we will provide you additional resources should they be of interest, and again, they're listed in the presentation. And FDA has spoken on the topic in some ways as it relates to software used in medical devices, and as well as discussed some cybersecurity issues in a number of guidances. But the takeaway from those guidances really are that baking in cybersecurity into the design of medical devices is important, as well as anything that will affect the safety and efficacy of the device. But really, the more recent activity is the FDA starting to define what is a medical device. All of these, whether it's Fitbits or devices that are being used to monitor insulin pumps or neuromodulators tied to Samsung phone platforms, the question becomes, what is a medical device? And that becomes a question because the regulatory definition of a medical device is extraordinarily broad. It includes any apparatus, any similar related article used in the diagnosis, cure, mitigation, treatment, or prevention of disease. Well, that could be just about anything that we've talked about. So the question is, does the entire regulatory scheme that FDA oversees for medical devices apply to these applications? and the significance of whether regulatory requirements apply, because there's a wide range of regulations that potentially apply, from everything from having to list and establish the location of a manufacturer to applying for FDA clearance and or approval, to quality system regulation, and then, of course, labeling and medical device reporting requirements. And how many of these regulations apply will really be a risk-based determination based on the classification of the device. So tongue depressors are an example of a Class 1 device where very few regulations apply, just some general controls. The majority of devices are Class 2 and have to go through a 510(k) clearance process, and then more significant devices that can affect more serious health issues certainly have to go through a more rigorous Class 3 pre-market approval application process. But the question still is being begged is, well, do any of these regulations apply? And what FDA has published in 2015, and there was an earlier guidance in 2013, is their guidance on mobile medical applications. And a guidance is certainly and simply FDA's current thinking of a topic. It doesn't create enforceable rights such as regulations do, but it does give you what FDA is currently thinking on the topic. And what FDA has essentially said is that they are going to exercise enforcement discretion to regulate devices based upon the intended use of the device and its function. And if the intended use really poses a risk to safety, a risk-based determination, and serves to cure or mitigate diagnosed disease, well, then FDA will regulate it. Let me give you a couple of concrete examples. A flashlight, an application on every cell phone. Will the FDA regulate a flashlight as a medical device? Well, the question is not a simple yes or no. It will be what is the intended use of, the objective intended use of the device. So if a flashlight is being marketed, promoted, labeled, advertised as an ophthalmoscope, well then, in that case, it would certainly be considered a medical device, and in this case, a Class 2 medical device subject to 510(k) regulation and pre-market clearance regulation. So the intended use is one key point here.
Hey, Barry, if I could just jump in, this is Brian Dolan again. For folks that are interested in CLE, I mentioned this at the beginning, you need to write down 4 code words, and here's the first one. It's going to be device, that's device, and then I will come on in about 15 minutes with the others. Thanks, Barry.
All right. Another example where FDA has exercised enforcement activities is with this U-Check urinalysis dipstick analyzer. In essence, the company promoted an application where a phone camera could be used to help analyze dipstick results. And what FDA said about this particular advertisement and promotion is that since the application allowed the mobile phone to analyze the dipstick, the device and the phone operated as a whole as a reader and therefore was subject to FDA regulation. In general, what the FDA is going to regulate will be medical devices that control a device using active patient monitoring or transform a mobile platform into a medical device, that really are looking at patient-specific analysis and or making patient-specific treatment recommendations. So that distinguishes the urinalysis system from, say, a Fitbit, which is not giving patient-specific analysis or patient-specific treatment recommendations, but more general wellness information. So the FDA does not intend to regulate tools that organize or track health information or help document information in medical records or provide simple calculations used in clinical practice. So as I mentioned, fitness coach or Fitbit or BMI calculators or APGAR scoring, all of that are examples that FDA has given that it won't regulate. However, this does not mean that just because FDA is exercising enforcement not to regulate the application, the FTC does not have an interest in how the information is being promoted, whether it's false or not, that HIPAA and high-tech will not apply if the information is being transmitted to healthcare professionals. Certainly, when the hospitals receive this biometric data, they become part of the electronic health record of the facility and therefore become covered information. And I'll talk a little bit more about how state consumer laws apply in this setting. FDA certainly has also expressed concern and interest in cybersecurity. This is a topic we've spent an entire seminar on, and those slides are available for download. But hacking is a concern of FDA. Hacking of medical devices has gotten the attention of OIG, and for the first time, OIG has placed in its work plan evaluating whether FDA is exercising sufficient oversight in electronic protected information contained within medical devices. So this is certainly an area of increased scrutiny. FDA has issued a safety alert this year on this very topic, urging transitioning away from devices that have been demonstrated to be subject to potential hacking. And in this case, it was the Hospira infusion system, which the FDA issued an alert noting about cybersecurity vulnerabilities, about unauthorized hacking created a concern that could interfere with critical patient therapies, and encouraged health systems to find alternative systems that are not subject to cybersecurity threat. And with that, I'll turn it over to Stefan. Stefan?
Thank you, Barry. Today, in regard to the FTC portion of the presentation, we're going to discuss the FTC's interest in mobile medical devices and apps, as well as a few FTC enforcement cases that I think would be helpful in understanding this topic and subject area. Why is the FTC interested in mobile medical devices and apps in the first place? Well, the FTC sees itself as a sort of super regulator, a big brother to all the other regulators, both federal and state. And the FDA and mobile medical devices and apps, it's no different. The FTC has a special interest in the safety of consumers and filling in what it perceives as gaps. While the FDA is an expert when it comes to the treatment, the safety and treatment of consumers, the FTC sees itself as having a comprehensive overview. So if you look in the area of safety and advertising, as I said, the FDA has some expertise in this area, but the FTC sees its expertise as expansive and all-encompassing. In terms of competition and economic impact, the FTC has a long history of bringing complaints and enforcement actions to protect the effect on the market. And the FTC has many antitrust cases that I would be happy to talk to you about at a later point. But in terms of the topic today, privacy by design and Internet of Things really has been a demonstrated interest of the FTC in recent years. When I say privacy by design, I mean the idea of promoting privacy throughout the entire organization at every stage of development. And the FTC is very interested in making sure that consumers know the types of products they're getting and that there's transparency regarding the privacy policies and security interests of consumers. In terms of Internet of Things, what I mean by this is the network of physical objects embedded with electronics and softwares that allow them to collect and exchange data. More people are wearing connected devices today or have them in their pockets, such as your cell phone, your watch, or even pacemakers. And as we learned from the television show Homeland, these types of devices can be hacked. This is why the FTC is interested. The FTC has a broad array of enforcement power, but much of their power comes from Section 5 of the FTC Act. And this allows the FTC to bring enforcement actions on that for unfair or deceptive acts or practices. When the FTC says unfair, what they're looking for is whether the practice injures consumers, whether the practice violates some type of public policy, or whether it is unethical or unscrupulous. But in recent years, this idea of unfairness has expanded. The FTC is not just concerned with bad acts when it comes to unfair practices. In fact, this definition is constantly evolving, and unfair has become something more akin to deviating from industry standards or minimal protections in terms of data security. Companies need to stay abreast of best practices in FTC settlements because that will tell them the commercially reasonable standards when it comes to data security programs. When it comes, in terms of deceptive practices, what the FTC means by that is a representation or omission that is likely to mislead the consumer. And it should be targeted to a particular consumer and one that is material, or rather would change the consumer's actions. So to use Barry's example, if you have this Fitbit or fitness watch, if a company advertises that it tracks calories and in fact it doesn't, that might be seen as a deceptive practice. In terms of the FTC enforcement actions, earlier this year, PEPFAR provided a comprehensive overview of 50 of the FTC's data security cases. And I won't have time to go into all these cases, but I would encourage you to review that presentation put on by Sharon Klein, Jan Levine, and Angelo Stillo, partners in our privacy, security, and data protection team. What I am going to discuss are 3 FTC enforcement actions that relate to the healthcare industry, as well as the recent FTC v. Wyndham case. With all of these cases, I'm distilling down the core facts and issues, but if you want to discuss the nuances of the case, especially that 92-page LabMD opinion, please give me a call. Let's look at the first case, Accretive Health. And in this case, Accretive was a company that provided revenue cycle operation services to hospitals. Basically, Accretive collected and maintained information about the hospital's patients, including sensitive health and personal information. It handled the back-end administration for hospitals. Well, the issue in this case was that Accretive used actual consumer personal information for training purposes and allowed an employee to put that information on his computer. Accretive did not make sure that that information was removed following the training, and the employee left the laptop in his car, and the laptop was stolen. In its enforcement action, the FTC alleged that Accretive failed to employ reasonable and appropriate measures to protect patient personal information against unauthorized access. From this case, we learned several lessons. Number 1, don't use personal information when it's not necessary, especially in training purposes. So if you need to use some type of example, use Jane Doe, or in the case of me, use fictional characters like Bruce Wayne. As it relates to mobile medical apps, only use PII if absolutely necessary. For example, if you design a mobile medical app to monitor someone's cardiovascular health, it might be important to have some type of unique ID, but you don't need to use a social security number. Or it might be important to know that person's age, but consider using a birth year or birth range instead of the actual birth date. The other 2 lessons go hand in hand. Protect devices that process personal information, and keep safety standards in place when data is en route. For mobile apps and devices, make sure that you use reasonable security policies for transmitting data that protect the data through all modes of transportation. And when you're transmitting data, use industry standards like secure socket layer encryption. Make sure that your data transmission is compatible with the devices for which your medical app will be installed. And if your device doesn't function properly, that can have vulnerabilities later on. Looking at the next case, GMR transcription services. In this case, the concerning act was that GMR provided services to transcribe audio files, including for healthcare providers, and these files contain sensitive information. GMR represented in its privacy policy that its services were secure and that they were also HIPAA compliant. But GMR relied almost exclusively on third-party servicers to provide this audio transcription, including transcription for medical files. As a result, GMR was unaware that these files were stored and transmitted in clear, readable text, and also that any common search engine could index these files, and it was available to the public without authentication. In its enforcement action, the FTC alleged that GMR did not adequately verify or require by contract that their service providers have reasonable security measures in place, nor did GMR request or review their service provider security practices or perform any type of audit or assessment. From this case, we learned that you should make sure that your service providers implement reasonable security standards. Put it in writing, and when you're contracting with third-party vendors, and verify compliance through audits. While many of our clients are tech companies, many of our clients are involved in other businesses, such as providing healthcare services. And it might be beneficial for those patients of those clients to have apps or devices that relate to the healthcare industry, even if they're not actually regulated by the FDA. FDA is a medical device. But if you engage a third-party developer, make sure that you vet the app or the platform and perform audits and monitor them. Ultimately, you could be held responsible for the actions of your third-party vendors. The next case that I want to get into is the Wyndham case. And while this case isn't exactly in the healthcare sector, I think it's really important in contrast to another case in the healthcare sector, the FTC v. LabMD case. So we've previously done a discussion over Wyndham. I'm going to be a little bit quicker with this discussion of the case. The action arose from 3 separate hacking incidents in 2008 and 2009, and it involved numerous customer records and millions of dollars of losses. When the FTC brought its enforcement action, it alleged a number of things, including that Wyndham failed to maintain reasonable security measures to monitor unauthorized access, that Wyndham failed to conduct investigations, and that Wyndham failed to reasonably limit third-party access to the company network. The FTC brought an enforcement action both under its unfairness prongs and deceptive prongs of Section 5. So Wyndham moved to dismiss at the district court level, and they challenged the FTC's unfairness authority under Section 5. Wyndham claimed that the data security practices were not included in the definition of unfair and deceptive practices, and they also claimed that the FTC failed to give them fair notice and due process because the FTC failed to notify companies of rules. So the District of New Jersey denied the motion to dismiss, but certified this unfairness claim for appeal. The Third Circuit affirmed the trial court, and it found that the FTC had the authority to pursue the enforcement action against Wyndham. And from this, the FTC said that unfairness does not require unfair conduct or unethical behavior, which you heard me say before. The FTC doesn't need to publish rules. Instead, manufacturers and companies can look at other FTC enforcement actions and other things that are happening in the industry to figure out what is acceptable cybersecurity practices. This case really solidified the FTC's authority to bring cybersecurity enforcement actions. And recently, within the last week or two, Wyndham actually settled with the FTC. The settlement was typical of other FTC enforcement action settlements, but it provided enhanced security standards or enhanced monitoring provisions. Now, let's examine this case in context to the FTC v. LabMD. Again, this is a 92-page opinion, so I'm hitting things at a very high level. LabMD was a privately held company that operated as a medical service provider, and it performed tests for patients at the request of doctors. As part of its business, LabMD collected electronic billing records and medical records. In May 2008, a third-party provider, or a third-party contacted LabMD and told LabMD that some of its files were available through LimeWire, a peer-to-peer file sharing system. After being notified, LabMD found the source of the breach, and it was installed on, the LimeWire was installed on this billing computer, which LabMD promptly removed. LabMD also used independent judgment to investigate, and it searched and monitored LimeWire for several months, making sure that there was no evidence of anyone downloading these concerned files except for that third party. Nevertheless, the FTC brought an enforcement action under Section 5 of the FTC Act. Let's quickly look at some of the allegations in LabMD versus the Wyndham case. You can see that even though they don't line up exactly, there's a lot of similarities. So the FTC alleged, among other things, that LabMD did not employ readily available measures to prevent or detect unauthorized access to personal information. And this is very similar to the allegation in the Wyndham case where the FTC alleged that Wyndham failed to maintain reasonable security standards. So in these instances, there were issues that were very similar. But what you will see is that FTC, that the administrative law judge who handled the case actually held very differently. He said that there was no evidence that any consumer suffered any actual harm from the alleged failure to employ reasonable data security. And there was no evidence of a high likelihood of future harm. So despite very similar allegations, the results were quite different. What are the lessons that we find? Well, it matters how you react to an alleged breach. You can take the lumbering disregard approach, or you can take the approach of quick vigilance. You should still the breach as early as possible. In the event of a breach, which is the second step, use independent judgment to perform thorough investigations. Breaches are scary, but it doesn't mean that you have to break the bank to respond to them. It's all a matter of reasonableness. LabMD was a relatively small company and it conducted an independent investigation, but Wyndham, a relatively large company, let things fester. Another lesson that we learned is to monitor computer systems to determine if unauthorized software has been installed. This is very important when it comes to creating mobile apps and devices. Traditional manufacturers have long audited and monitored production for product defects. You should do the same with your mobile medical apps and devices. Audit your coders and designers to make sure they're implementing approved privacy and safety specifications. While certain code may optimize performance, it may leave you vulnerable in other instances. And the last point is that breach does not necessarily mean liability. I, of course, say this point with a caveat. This opinion is from an administrative law judge, and the FTC has appealed the decision. There's been a circuit split regarding what the FTC, or any plaintiff for that matter, needs to prove in order to bring a claim related to privacy. And I should also mention that the Supreme Court is handling this issue, albeit in a different flavor, in the Spokio case. But I'm struck by Judge Chappelle's words in the LabMD case. He says, at best, the FTC has proven the possibility of harm, but not any probability or the likelihood of harm. Fundamental fairness dictates that demonstrating actual or likely substantial consumer injury under Section 5 requires proof of more than hypothetical or theoretical harm that has been submitted by the government in this case. This is an admonishment both to the FTC but also the companies. So under Section 5, the FTC must prove that there was unauthorized access, or rather a breach, but they also must prove a reasonable likelihood of harm. This last part is where the FTC failed to meet the standard in the LabMD case. For the FTC, the holding is saying, yes, FTC, you have the authority to bring these types of actions, and you can survive a motion to dismiss, but unless you come to trial with some proof of actual injury, or at least a high likelihood of injury, do not expect to pass go or collect $200. For companies, the holding implies that if you are vigilant in responding to an alleged or actual breach, you may eliminate any harm to consumers, and thus the FTC will be unable to show reasonable likelihood of harm. Think about what LabMD did. They investigated the breach, they stilled the breach, and they monitored it to see if there were any subsequent leaks. This is a positive statement for manufacturers of mobile apps and medical devices. But it's not to say that the FTC or other regulators will take this lightly. In fact, state attorney generals are dealing with some of these very same issues, and Barry's going to get into this in our next section of the presentation.
Yeah, thanks. Before Barry starts, this is Brian Dolan again. For those of you looking for CLE, you need to write down the 4 words. The first word was device, and the second word is going to be medical. Excuse me, so that's medical is the second word, first word is device. Thanks, Barry.
Thanks, Brian. Now, state attorneys general have expressed intense interest in these two related issues of privacy and patient safety, as well as interest in the pharma and device world life science companies in general. And I'm going to talk a little bit about how their laws and enforcement activity may be important to you. Congress has been considering, debating, discussing a number of different laws that affect privacy, but have been unable to enact any such laws. But what was interesting to me was a letter that 45 states' attorney generals wrote to Congress this last month, really imploring Congress not to preempt state attorney generals' efforts to protect consumers from any type of privacy concerns. In the letter, the attorney generals noted a few facts. One, how much harm is caused consumers from the attorney general's perspective from any data breach, how important a role they have played over the last 10 years in enforcing both state consumer protection laws, but also very specific data breach disclosure laws. And again, they've asked Congress, whatever laws are passed, not to preempt those efforts. And one of the main arguments that the states have made is, one, how effective they have been, but two, how sometimes data breaches are more local, that perhaps the FTC may be interested in enforcing larger cases, national cases, but when a data breach hits the local newspapers, the state attorney generals get involved, and their big and small data breaches capture their interest and enforcement activity. In fact, 47 states have enacted data breach notification laws that require notification of breach to consumers. Some require companies to adopt reasonable data security practices, and all provide for additional potential liability and impose civil penalties for failing to properly notify consumers in a timely fashion, and the time varies state by state, of a breach. States enforce their data breach laws typically through voluntary assurances of compliance or consent decrees. And in this space, as well as when talking, and Stefan talked about the FTC enforcement activity, there aren't always so clear rules of the road. Section 5 under the FTC is enormously broad, and you're going to see that state consumer protection laws patterned after Section 5 of the FTC are equally broad. So there isn't tremendous guidance that's given by clear federal regulation on a number of these issues. And I know we've seen some questions already that ask about, well, where can we find guidance as to whether a particular activity will protect us from FTC enforcement or Attorney General enforcement? And the answer to that question is largely found in watching the enforcement activity. That consent decrees entered after FTC activity or after state attorney general activity is really where the rules of the road, where the standards are being promulgated step by step. So what does a typical consent decree look like in a data breach case? Well, one, there's some monetary payment. Penalties, civil penalties or fines are likely imposed. But there's also some affirmative obligations that are imposed upon companies that are involved in data breach, including creation of new policies and procedures to make sure that they can comply with data breach disclosure laws, providing free identity theft protection and mitigation services, mandatory audits with reporting back to the states, creation of security-based roles like a chief privacy officer, mandatory training requirements, and even updating some technology infrastructure, all are part of what attorney generals have imposed after data breaches. But in addition to specific data breach disclosure laws, the states have broad authority under, or they believe they have broad authority under their state consumer protection laws. One, a violation of a data breach disclosure law can itself be a violation of an Untrade Practices Act or consumer protection statute. In addition, creating a deceptive privacy policy can be a per se violation of some states' consumer protection laws, and indeed be a criminal violation in some states, including the one that I'm sitting in Pennsylvania. But these state consumer protection laws are also just incredibly general. They can cover activity that is, quote, capable of misleading, or violates public policy, or simply unfair, or concealing or omitting a material fact, all of which can arise in how privacy policies are communicated or how patient safety and protected health information is being protected. And again, the enforcement by state attorney generals can include injunctive relief, restitution, civil penalties, and disgorgement of profits. I want to pause on the last bullet point for a minute. No proof of harm to collect civil penalties. That's certainly the position that state attorney generals take when trying to impose their consumer protection laws. But decisions like LabMD in the FTC context certainly need to be watched carefully. As Stefan mentioned, it's an administrative law judge opinion subject to undoubted appeal. Every circuit has their own take on how you prove or don't prove damages, but certainly it shows that the standards for FTC, and then one would argue by extension to state consumer protection law application, does not have this impossibly low standard of no proof of penalties. But I will tell you that state attorney generals certainly believe that any technical violation can create a right for civil penalties for every single violation that occurs. Not only are state attorney generals watching, but the private plaintiff bar is watching, and Stefan will touch a bit on consumer class actions in this space.
And actually, this is Brian Dolan again. While we make this transition, let me give you that third code word. The third code word is going to be data. That's data. So the first was device, second is medical, and third is data. Thanks.
Before I get into the consumer class actions, we received a question, and it asked, was GMR decided prior to the changes in HIPAA regarding business associates to comply with the privacy and security rules and expanded their liability under those rules? If I remember correctly, I think the business associate rule, those went into effect in January 2013, I think. And GMR was decided, settled into, this was an enforcement action, so I just want to be clear. It wasn't a court decision, but an enforcement action based on the FTC's enforcement power under Section 5, and GMR and the FTC reached a settlement. They reached that settlement in late 2013, early 2014, and so while I think that the FTC probably took this into consideration, as far as I've read the enforcement action and the documents associated with this, I don't see an actual mention of HIPAA in it. But what I will say is that a lot of these standards, HIPAA, high-tech, the PCI DSS, they're all starting to converge on the same areas that the FTC has put out in its Start with Security guidance. And so, though it's unclear on whether the FTC actually considered HIPAA in the GMR enforcement action, I would certainly say that the principles that HIPAA has in place were certainly considered. And to whoever sent that question out, if you would like to discuss that issue more as it relates to you specifically, I'd certainly be happy to set up a time to talk with you. But let's get right into this consumer class action section. In addition to the state and federal government authorities, mobile apps and providers are at risk class action suits brought by private litigants. And private litigants in some aspects serve as these private state attorney generals. Now, as you will see, these cases have a lot of similarities between the FTC enforcement actions that I previously discussed, so I won't go into as much detail with that, but I want to highlight a few points. With the Sutter Health case, in Sutter Health, an unencrypted laptop was stolen, very similar to the Accretive case. But this class action was brought under the California's Confidentiality of Medical Information Act. And I bring up this case to note that the FTC enforcement power under Section 5, resolution of lab MD pending, provides a lower threshold for liability, whereas for private plaintiffs, the threshold is higher. And the plaintiffs in this case were unable to meet that threshold. So Sutter Health brought a motion to dismiss the complaint and impose class certification. And the trial court denied Sutter Health's motion. But the Court of Appeals vacated the decision and ordered the case to be dismissed because there was no evidence that patient information had been accessed or viewed by an unauthorized person. What are the lessons we learned from this case? Well, as I already mentioned, state statutory law has the potential to expose recipients of health information to large damages awards. And we've seen this in other contexts. I'm sure all of you, or at least some of you, have heard of the Target case where privacy consumer class actions in other cases like it have settled for millions of dollars. But another lesson that we learned is even if ultimately successful, opposing class actions brought on state statutory grounds can be costly. So the motion to dismiss stage has become more and more important. And if you can win at the motion to dismiss stage, you can cut down on a lot of these costs. We've seen this from other cases outside of the healthcare context, like the GM, Ford, and Toyota alleged hacking case. For those who are not familiar with that case, plaintiffs brought claims saying that these GM, Ford, and Toyota cars that they purchased were susceptible to hacking. But the plaintiffs were actually unable to show that the cars had been hacked or any evidence of hacking outside of a controlled, tested environment where a tech person simulated the hacking. And because the plaintiffs were unable to show actual injury, the case was dismissed and defeated before the class certification stage. Another lesson that we learned is that securing physical medical devices is equally as important as securing access to that information. And I realize this gets tricky because as a business, you have control over your employees, but you don't always have control over the consumers of your product, i.e. your customers. One thing that I would encourage you to do is to work with device manufacturers to ensure that in an event a device is lost or stolen, sensitive information and access to that information is cut off. For example, Apple has a remote access feature that allows information to be erased in the event that a device is lost or stolen. The next case that we'll look at is the Nike fuel ban case. And this was a purported class action brought in California State Court claiming that Nike and Apple falsely advertised that their electronic wristband accurately records calories burned. So as I mentioned before, with the FTC Act, this would probably be a deceptive practice under the FTC Act, but the case actually settled very quickly for a $15 check or a $25 Nike gift card and $2.4 million in attorney's fees, all paid by Nike. So the lessons that this teaches us is be careful what you advertise your product does. If you say that your product records calories burned, make sure that it actually does. As I already know, the FDA and the FTC, the state AGs are concerned with false advertisement, so it's no surprise that consumer classes share those same concerns. Then also, I would say when working with collaborators, make sure that you're able to hold your collaborators to your standards and/or seek indemnification. From a business standpoint, you're responsible for your own brand and reputation. But from a liability standpoint, if you have concerns, you can manage those risks by seeking indemnification, as I'm sure Apple did in this situation. We also advise our clients to include a right of audit clause in any type of joint venture or contract with a third-party vendor. It's important to look under the hood even if you expect that everything is working smoothly. So we're going to shift into some final thoughts that we have that will help you make sure that you're able to comply with the regulation under the FDA, FTC, or the state AGs, or at least give us a call if that triggers any type of concern in your head. I mentioned before that the FTC put out this Start with Security guidance, and that's where it analyzed 50 of its data security cases related to enforcement action. Again, I'm not going to go into all the detail, but I take this as an ending point because a lot of the the different standards like HIPAA and NIST and the FDA guidance, or standards that are not from government regulators but are in the industry, like the payment card industry's DSS. They're all converging on the same area, and I think that the Start with Security guidance gives us a good framework. So again, I would encourage you to review that entire presentation, but I want to pick out 3 steps that I think are really important to the medical, mobile medical apps and devices. Steps 1, 8, and 10. So step 1, start with security. Don't collect personal information you don't need. As I said before, if you could use someone's birth year or birth range instead of their actual birthday, do that. A hacker can't take what you don't have. Don't hold on to information longer than you have a legitimate business need for it. Of course, this will be different from different organizations, and certainly different as it comes to different projects in organizations. If you're doing a longitudinal study, certainly you will need to hold on to this information longer than what you would if the study is only lasting a couple weeks. And don't use personal information when it's not necessary. We discussed this earlier with the training program in the Creative Health case. But this also applies to when collecting data in general. If you can use anonymized data or de-identified data, consider that as an alternative. Looking at step 8, make sure your service providers implement reasonable security standards. Put in writing when you're contracting with your third-party vendors and verify compliance through audits. Unlike the old adage, don't look a gift horse in the mouth. You're paying for your contracts and the products provided by third-party vendors, so you should audit them and you should assess whether they're meeting your security standards. Now, I know I focus a lot from the healthcare providers in direction to the third-party vendors, but I would also say, in terms of third-party vendors, you should look and make sure that you know the standards that you're being required to meet. Like, make sure that you have a reasonable understanding of what requirements that the parties in which you're contracting with expect of you. And the last thing, secure paper, physical media, and devices. Step 10, securely store sensitive files and protect devices that process personal information. You want to keep safety standards in place when data is en route and dispose of that data securely. So, you know, a lot of times I've traded in my phones and I've always made sure to delete all the data off of the phone. The same thing applies when you're manufacturing a medical device. If that device is being used again, make sure that all the information that could expose your patient is deleted and taken care of. We got a question, is encryption a safe harbor under the FTC rules? One can acknowledge the safe harbor of encryption under HIPAA, which is regulated by OCR. I certainly think that encryption goes into the analysis of whether someone is committing an unfair practice under the FTC guidelines. You know, if you have files that are encrypted, even if they're stolen, there's less likely to show that there was a high likelihood of harm. But I don't think that encryption by itself is going to get you out of it. I think it's a comprehensive analysis, but certainly encryption will help with showing that there wasn't an actual harm and that you took reasonable steps to protect consumer information. Again, I don't think that the FTC or courts are requiring you to have perfect compliance, but they are requiring you to take reasonable steps to ensure that you are complying with applicable regulations and law.
But if you don't mind, I'd like to just give that last CLE word before we hit the top of the hour. The 4th word is going to be pepper. That's pepper. If you're looking for CLE, you needed to write them all down. 1 is device, 2 is medical, 3rd is data, 4th is pepper. Thanks, Barry.
So we have some questions to ask yourself, you being our client, and after you ask them, if you still haven't figured out, give us a call. But what is the function and use of the device? So I think Barry mentioned this before, and this relates to the second question as well. Is it a non-mobile device with the same function already regulated? If you're having a device that you intend to operate or it is intended that it operates very similarly to a device that's already on the market that isn't a mobile device. Be mindful that, and expect that that might be regulated. So if I have a device that's supposed to, a mobile device that's supposed to monitor my cardiovascular health, but I have a non-mobile device that does the same thing, I think it's fair to assume that the FDA would be interested in regulating that type of device. Who are your customers? You know, certainly if you have certain customers, it may expose you to more regulation than others. So if you're dealing directly with consumers, like all of us, I think you can expect to have more scrutiny. But if your customer, you being a third-party vendor, are hospitals and other people in the healthcare industry, think about the regulations that you might be subject to. So HIPAA is definitely going to apply, and even though your device may not be regulated under the FDA, if it's communicating health information, that might subject you to regulation.
And Stefan, I'll just add and emphasize really the last point on this slide. What standards are established in developing the product? The first question would be, are you regulated and how are you regulated? But also in this space, there is not terrifically clear guidance. Some guidance documents exist, but it really is through monitoring enforcement where those standards are being built, whether they be FTC enforcement actions or through consumer protection consent decrees. So there's regulation that may apply, but if you're not under a specific regulatory regime, the consent decrees are really important to follow, to understand where the standards are evolving to that set the expectations of the regulators.
Yeah. So I think at that point, we're reaching near the end of the hour, and certainly if there are other questions that you would like to bring up, please shoot Barry or me an email, and we would love to discuss with you the specific issues that are facing your organization. But I think that I'm turning things back over to Mark just to finish up with some closing thoughts.
Well, thank you very much, and the two of you have done an outstanding job today of taking us through this very, very interesting area. I think we have another slide or two, Brian, and if we can put those up. First of all, to point out to everybody on the call the important resources we have for regulatory guidance, many of which have been cited throughout this presentation. And then I think also we have some PEPR resources that exist, and you can see the citations to them there. They are client alerts and publications that PEPR has done. They're all available to you on our website, and to show you the depth and breadth of our knowledge with regard to privacy and security issues. Half of healthcare institutions have experienced cyber attacks in the last 12 months in this country. And the costs of this, both in terms of direct cost and in terms of lost use of employees who've had to run around to try to put their fingers in the dike and stop the leaks or detect the leaks, is $6 billion. This is a serious ongoing problem. It's not going to get better. It's going to get worse, particularly with the proliferation of all of these devices in the healthcare setting. And if we have another slide, I think, which shows us what I like to call the wheel of misfortune. And please understand that the range of enterprise risks, as we've seen before, not only are in the legal area from lawsuits, but also with regard to regulatory compliance, diversion of resources, as just mentioned, financial impact, and most importantly, in the healthcare environment, a damage to the reputation of our healthcare providers who are involved in a very trusting relationship. And of course, obviously, when there's a potential for breach, or an actual breach, there's a loss of trust in the environment. Thank you all very much for your attention. And as mentioned, we have CLE credit available, and we do have contact information for our two speakers today. And please direct your questions to them or to me in this very, very important area. Happy holidays to everyone. Thank you.
Thanks, Mark.